everyone, good evening. We're just about to start the final panel, and I'm mindful of the time. I don't want to release you guys too late so that you would end up getting caught in traffic heading home. So we'll just go ahead and kickstart the panel for this evening. So thank you so much for staying until the end of the day. Last panel, and I hope we'll be able to, give you some insights really in terms of the world of e-commerce and the movement of goods. As you can see the heading, we're talking about really, e-commerce meeting the reality of movement of goods, right? When trade, sorry. Yeah, so when trade moves from physical and e-world, what are the trade customs, consumer protection, as well as other regulatory issues? So really, the world of e-commerce has grown so much, right? And how then have the laws on movement of goods actually caught up? So here we have today really a panel of all female panels, right? Our strong ladies squad that we call ourselves, and where we can just really kind of share with you a little bit of insights about trade and customs and some thoughts. So as mentioned throughout the day, if you guys have any questions, feel free to just interrupt the panel anytime, just to say hi. I have this question for you guys to consider and talk about, and we'll be happy to do that to the extent that we can. Okay, just very quickly introducing the panel we have here today, maybe starting from my most far right. We have Ibu Nazli from our Indonesian office, who heads up our tax practice and customs practice in Indonesia. We have Kun Melissa, who has been here for speaking for the whole day already, so bears no further introduction. And Skala as well, who has been with many of the panels, and myself, Tracy, from the Malaysian office. And today what we hope to do is just give you a little bit more insight in relation towards movement of goods and from a trade and customs perspective. So without further ado, let me move into the very first question. So as this world of e-commerce we're in, and really we're looking in towards moving of physical goods, and generally everyone understands how goods move physically, right? What about electronic goods? Have customs laws actually caught up towards figuring out how to tax the import and export of electronic and intangible goods? Nazli, I understand Indonesia has done quite a bit on this. Why don't you share from that perspective?
Oh, thank you. Thank you, Tracy. Hi, everyone. I'm Nazli from Jakarta office. I don't have the badge, but my beautiful colleague can testify that it is the real me. Yeah. I didn't know who took away my badge. I didn't know I have a secret admirer here in Bangkok. So whoever took my badge, yeah, keep it as, remembrance. Anyway. Recently, Minister of Finance in Indonesia passed the new regulation, Regulation 190, which is effective 13th of January 2023 this year, which regulates the importation of intangible and digital goods. And why is it important? Because according to Bain's company, the famous consulting company, Indonesia has a gross merchandise value of 77 billion United States dollar in 2023, which is going to be higher in 2023 this year. It's not going to be a surprise to you, yeah, because Indonesia has almost 280 million population, and every one of them is either YouTuber or TikToker. Including myself, I'm a YouTuber. So if you subscribe to my YouTube channel, you will get free advice, okay? So because of that, the government passed the regulation which simplify how the importer import the digital goods into Indonesia. The first thing is, because the digital goods are going to be imported electronically, we bypass the physical inspection. What does it mean? It means you are not going to see all this dreadful inspector who is like bulky with the sniffing dogs, yeah, at the port, with long mustache that's never been shaven for months. So you're going to pass all this trouble. Instead, you're going to send all the documents electronically. And in addition, the regulation will determine how much tax, how much import duties, how much VAT that you need to pay. You know, Indonesia, we tax everything, importation, exportation, everything. We are like the UK, but with pollution and dirtiness, okay? We tax everything. So, if you want to know how much you're going to pay tax, then you know now because of this regulation, okay? So, if you want to be importer and you want to know how much I have to pay for the Indonesian government, look up this regulation. And if you have trouble understanding, call me. And if you subscribe to YouTube channel, of course it's free, okay? Anyway, now because of that, it makes life much more simpler, much more certain. Because Indonesia loves uncertainty, because uncertainty means that there's going to be dispute. But now there is certainty how much you are going to pay for the importation of digital goods. Thank you.
Thank you, Nazli. I did say you're in for an entertaining hour, or did I? With Nazli, you'll always be entertained. But really, Indonesia has been on the forefront of this in terms of taxing intangible goods and the import of intangible goods. Just quickly sharing from a Malaysian perspective, we don't have that yet. Our customs laws have been amended such that it does cater for the definition of import to mean import by any means whatsoever. So it does have a little bit of a signaling that the government is looking into that, but no regulations as yet have been drafted towards actually, the government, I don't think, has actually figured out how to actually catch all the intangible imports and then figure out a manner of taxing it. Instead, what we do have is this aspect of service tax on foreign service providers. So if you're providing your digital services online, right, your Netflix, your Spotify type of services, the gaming services, stream and all that, these are then taxable because the foreign service provider then have to be registered to provide once they hit certain thresholds, they then do need to provide service tax on that, chargeable on that. Melissa, I believe Thailand has something similar?
Yes, we have a very similar model for the same reason. It is really difficult to use customs laws, which are geared around the importation of intangible products, to pick up intangibles. So there is still, you're correct, it's the same treatment here. The very definition of importation is very broad, but the practical application of importing intangible assets or goods makes it very hard to tax. So Thailand also went down the other path where they apply VAT on foreign platform service providers. So they make it the foreign platform service provider's duty to register and pay VAT when they are selling digital services into Thailand. So they have a duty to register when their income exceeds 1.8 million in the country and pay appropriate VAT. And I just recently read somewhere that just in the 8 months between October 22 and August 23, the amount of tax revenue that generated for Thai tax authorities was 1.59 trillion baht. I'm not even sure how many zeros are there, more than billion. So it is clearly a massive generator of revenue for Thai authorities, and that's the way they're trying to deal with the very practical difficulties of importing intangible goods.
Yeah. That's absolutely right. Carla, anything to add from a Singapore perspective?
So first, excuse me. So from a Singapore perspective, if it's intangible goods being exported, because it doesn't go through sort of customs as such, there are no requirements whatsoever. And I'm not talking controlled goods here, just general goods. No customs requirements. We don't have VAT equivalent GST, goods and services tax, when it's for exports to be used elsewhere. So it becomes zero rated as such. So there's no tax payable potentially. So the reverse might be true if there's import. However, of course, because it's sourced in Singapore, potentially, if your exports are occurring from Singapore and payments received in Singapore, taxation, that's basic rule. So revenue is sourced, you'll have to pay taxes on it.
Thank you for that. So you did mention a point on controlled goods, right? So that leads me to my second question. So really, whenever we talk about intangible transfers of technology, most of the time we think about it from a controlled goods perspective, dual use perspective. Maybe Carla, you could share a little bit from the Singapore law perspective on that?
So we reference controlled goods sort of very broadly. There are two key categories as far as controlled goods are concerned. The first is where it's military use or dual use goods. In Singapore, in Malaysia, we call them strategic goods. In other countries, they may not use the phrase strategic goods, but they will just go with dual use or ML, military list goods. And then you have controlled goods, which are like chemicals and so on as well. And so that's a separate category. Now, in relation to strategic goods in particular, what's regulated is the export of strategic goods are regulated. It just hit me that it's about 20 years since these laws have come into Singapore as well. Time has flown. But the enforcement of it probably only really started in a big way about 5-6 years after the laws were introduced. The laws were likely introduced because of 9/11, which is now many years ago as well. Now we're looking at two elements of it. There's the physical goods which move, and those can be subjected to Strategic Goods Act, which means you need to get permits over and above your typical export permit. So there's an additional permit. Now, if you're looking at intangible goods and you're exporting the intangible goods by using your laptop and pressing send, that's deemed an export. And for that as well, you will need a permit. But does it capture all kinds of intangible goods? No. It's only intangible goods which potentially have a dual use or has a security element. So to use a software, if you require a key, a code, that could potentially require this special permit, the strategic goods permit, for example. It sounds somewhat odd and difficult to manage, but it is something that I think across many countries it's now implemented, and compliance is necessary. One other complication I want to add to that, if I haven't already complicated it, is increasingly, and this is more so in the last half a decade or so, a lot of things are stored in the cloud. So I don't even have it, say, in Singapore. So when I'm exporting, is it really going from Singapore out of Singapore? Or is it going from the cloud being in Indonesia out of Indonesia? So it gets very tricky. For now, we just take the position that we look at where the servers are located. But it's not always so clear-cut either. And this is an area that's going to get more complex over time. I mentioned the key, right, in terms of intangible transfer. I just want to mention a couple of other things as well. If you're looking at design plans that go towards building specific semiconductor-type products, which could end up having a military use, for example. If you're looking at plans that build a certain type of vehicles, whether man-controlled or not, those could also attract this additional strategic control permits. It is across the world, it is serious, it is enforced. ASEAN-wide, it will come to pass that all 10 countries will have it.
Thanks very much for that, Carla. So position, and I thought to just share a little bit about the position in Philippines. Our partner, Deborah, was meant to join us on the panel, but unfortunately she couldn't make it for this trip. So she gave me some notes, bear with me. I'm not a Philippines lawyer, but I'm just kind of cribbing off her notes, right? So Philippines has a similar Strategic Trade Management Act. And what is interesting about Philippines that's quite different from the position in Singapore and Malaysia is it's not limited to exports. It includes imports as well. So import means really refers to shipment of strategic goods or transmission of software technology by any means from a foreign country into the Philippines, and exports the converse. So really their Strategic Management, Trade Management Act, their STMA, does look in towards both the import and exports of technology. So please do keep that in mind, really, especially if you have businesses in the Philippines, that you do need to navigate around this issue, because the permits are then for both ways. The position in Malaysia is quite similar with the position in Singapore. We are looking more outward bound, exports basis. So in that case, really the same issues would come to pass, right? And some concerns we did come across with some of our clients is that, look, they are in the business of those cybersecurity testing type of products. And what they do is they have their penetration testing related products. Depending on how sophisticated the software is to conduct those type of penetration testing tests, what if then it could potentially turn into a dual use item, because it can actually be used for hacking software. So that these are all different elements in terms of, if let's say, for example, you're a cybersecurity provider or your service provider has this, then would then export control permits come into the picture. So some things to think about. A little bit beyond e-commerce, but we're wading into the digital world here. And what we are trying to emphasize is that, look, we're beyond just movement of physical goods, but really intangible goods that do attract their own set of complications and problems. And with Indonesia paving the way, in terms of taxing intangible goods when you import or export it into the country, who knows, it may be a matter of time before our other ASEAN countries catch up, seeing the amount of revenue that the Indonesian customs is receiving from this. Okay.
Maybe I can just note, just for Thailand, that we also have that same strategic goods law. It's called the Trade Controls of Weapons of Mass Destruction Act. It's a very frighteningly named act. But I just wanted to read out the definition, or a summary of the definition of dual-use items, because you may not think that what you export, and the Thai law is export-driven, would be caught, but it could be. And a dual-use item is an item that could be utilised both civilly and militarily, and could be used to design, develop, manufacture, apply, modify, store, or transport weapons of mass destruction, or could be treated by any means in order to acquire weapons of mass destruction. So it's something, it sounds like something from a doomsday, post-apocalyptic movie, but it could be any type of software as well. In the Thai laws, they're relatively new, they're just several years old, very little enforcement, if any. But the good thing for us is that there is a lot of onus on the regulator itself, on government agencies, to identify where they think there are some goods or activities that may have a reasonable suspicion of needing an export license. So there's more of a burden on government authorities as well to identify instances where it needs to be regulated. But generally in Thailand, we don't have a lot of export licensing requirements compared to some other countries. That's all.
Thanks very much for that, Melissa. So we'll move on to the next point, really, in terms of some common issues that you face in respect of the movement of physical goods. So we've given you some doomsday scenarios in terms of intangible technologies. But physical goods, whenever we think about, no, I buy something online, it needs to be shipped into our respective countries or back to my door. You would think, oh, everything goes fine and dandy, it moves really well. No, you'll be surprised by the amount of issues we're going to encounter. So, Nazli, you have a lot of stories on this. Why don't we hear from you?
Okay, movement of physical goods. Anyone is interested becoming importer into Indonesia? No? Why not? I will help you out. Okay, first thing that you need to do if you are interested in delivering product into Indonesia is buy a map. Okay, why? Because then you see how big Indonesia is. Indonesia consists of 13,677 islands. Can you repeat that? 13,667 islands. And I've been to 9 islands only. So the eastern part of Indonesia, all the way to the western part of Indonesia, can cover continental Europe. What it means is that if you say, oh, I'm going to deliver product into Indonesia, you deliver product to Jakarta, perhaps, okay? Because the very eastern part of Indonesia, which is Papua, is so far away. So the cost of one banana in Jakarta costs 10 times in Papua. The same banana, the same, not as tasteful as in Bangkok banana, costs 10 times in Papua. So in summary, you need to have a huge of patience being imported into Indonesia. If you don't have any patience, then forget it. Because in Indonesia, everything takes forever. Why? Because we enjoy life. We don't care. Urgent, what does it mean? Come on, let's have some tea and enjoy life. Enjoy the sunshine, enjoy the beach, okay? So you have to have lots of passion. We change the regulation all the time. Why? Because if the regulation is not changed, then our assemblymen do not have any job. Okay? So we change all the time. And one regulation conflict the other regulation. It's a day in Indonesia. Don't get mad. Just be happy. Okay? And then the infrastructure. Sometimes you think you want to deliver clothing all the way to the eastern part of Indonesia. You're going to take plane all the way to Jakarta, and then from the Jakarta all the way to Surabaya, and then what? Those islands, we don't have bridges. Then you have to deliver by boat. The boat come every 2 weeks. Oh, what happened then? See, you have to be really careful. So it's not easy. The infrastructure in Indonesia is so complicated, so it's not easy. It is not surprise that the logistical costs amount to 24% of our GDP, the highest in the world. And if you are lucky, you get to the port again, is so inefficient, corruption is rampant, and you have to face with so many difficulty that people never tell you. I'm Indonesian, so I am telling you now, before you get surprised, okay? Then finally, one of the hurdle about importing goods into Indonesia is the central government is like a dog. They want to control everything. So they're not going to let you do everything on your own, you know. They want to know what's going on in this island, what's going on in that island, something like that, okay? And this is one of the things that you have to face. But above all, don't worry, please do send your product into Indonesia. We are the largest domestic population in the Southeast Asia, 280 million. And the middle class is growing, which means the purchasing power is increasing. So if you send your product into Indonesia, the probability that it's going to be bought is highly probable. Thank you.
Thank you, Nazli. Melissa, care to share anything from the Thai perspective?
I can't follow Nazli. I think life here seems simpler by comparison. We don't have the 13,677 677 islands. Okay, I will not forget that now. Logistics is simpler here. I think in terms of importation of goods, the main areas that we would have, I think if as an individual you buy from an e-commerce provider and you import, you'll see that at some point they will reserve an amount for duty, right? That is generally because we have a de minimis rule of 1,500, which is based on the cost of goods, insurance and freight. If you go over that, then you're subject to import duty. But the difficulty that you tend to face here is valuation. If you bring products in at any amount and the customs authorities disagree with your valuation, they will reject your import entry and issue you a notice of assessment eventually. what often happens is your goods get stuck at port and you cannot clear them through customs, and your freight forwarder comes and tells you that this is what customs is declaring. They want you to settle the dispute, sign the settlement form, you pay the difference, you pay a fine, and you bring your goods in. But the difficulty we experience there is that when you settle, that operates as an admission of wrongdoing, so it's likely to come back and haunt you for all future imports. So what we always say is don't allow your freight forwarders to just settle any dispute with customs just because you need to clear goods urgently. You should first of all look at what is the situation with these goods. What is the dispute about? Can you defend your transaction value using the Customs Act and the WTO provisions? What is the history of these goods? Are they suddenly disputing imports, but you have 5 years worth of them? And so if you settle the dispute that you have, they will then go back 5 years and reassess. So you have a lot of risk. And at every stage you may be pushed to settle because, you know, one bad thing that happens here is if you do settle and you pay a fine, you are helping to provide a retirement fund for those officials who act as informants, because it is legal under the Customs Act for them to share in a portion of the reward. So it's this reward system that drives customs disputes into the criminal area so that you can be forced to settle, pay a fine, and then they share a portion of the reward. So in Thailand, when you have a dispute, it could either be a civil dispute or it could be a criminal dispute. And if it's a civil dispute, then if you are unhappy with what customs is assessing, you can appeal to the Board of Appeal, you can follow the formal steps. But what often happens, unfortunately, is you get accused of duty evasion, or you get accused of, you know, importing a good without a restricted good without a license, and at that point you're getting pushed to settle, and to settle quickly. And often you have goods stuck on the at the port, and you need to settle quickly, or you need to move them quickly. But I would say it is not the right thing to do to settle without first examining what are the potential ongoing ramifications. I mean, just recently we were in the tax court appealing against a Board of Appeal ruling, where one thing that made our case very difficult is years back the importer signed to settle a customs dispute, and it was just in relation to one import entry, but they have multiple import entries that they've declared at the same tariff. So this was a tariff classification dispute. And of course, customs raises that in the proceedings as evidence that we admitted wrongdoing. We admitted that it shouldn't be this tariff classification, it should be that classification. So I think the very simple advice I would give is to just slow down when a dispute arises, to not immediately, you know, empower your freight forwarders to settle. I think the other thing I would say is if you are bringing in new products for the first time, look at whether you want to do an advance ruling application. So either an advanced tariff classification ruling or an advanced valuation ruling. You have to do it at least 30 days before the goods come in, and then once customs issued it, it would be usable for the next 3 years. So you have to make sure that your goods still have the same characteristics, but that is one possibility. But that would only really work for goods that you have not imported before, you know, at that particular description. Or so the very practical advice is to plan before you're bringing in particular goods, particularly if it will be a long-running importation or if it's a high-value importation. And the second thing is, if you do have a customs dispute arise, do not just settle it immediately. I mean, assess what is the monetary exposure, but also look at what is the number of shipments involved. I mean, for criminal duty evasion, the limitation period here is 15 years, which is, not pleasant.
Very good. Thank you so much, Melissa, for that very practical tip. Very doom and gloom from from Indonesia and Thailand. Carla, care to share from the Singapore perspective?
Sure. So looking at imports from the Singapore perspective, firstly, we also love to enjoy life, but we are only 5.5 million people. You can drive east to west in less than 40 minutes when there's no traffic, and north to south in 25 minutes max, kind of thing. This is even after we have grown our island size by about 10%. We reclaim land. So anyways, we enjoy life, but we always want everything yesterday. So not will wait. Everything's yesterday. I don't know how we do it, but yeah. So that said, coming to import specifically, I think with import, the concerns are a little perhaps less than export. Having said that, I think key points to note is we have practically zero duties on everything. So customs cases don't come up so often unless they are in relation to rules of origin and arising out of free trade agreements, but more of that later. We do have issues in relation to GST. So sometimes people forget that if they are importing into Singapore, you do have to pay goods and services tax. It's at 8% now. It'll go up to 9% next year. That's like your VAT. Then there are a whole range of different types of products which require licensing or a permit. Food is right on top for various reasons. It's hygiene and so on and so forth. You will require different types of permits. But apart from food, healthcare products, a whole range. Even cosmetics, I don't require a permit for cosmetics, but I have a notification requirement that I need to provide. And I mentioned cosmetics, food, because a lot of that comes through e-commerce. It's bought online as such. So when you're selling it or you're trying to market into Singapore through an online platform, then the question is whether the platform is responsible or is it the retail shop or e-shop, as we call it, responsible. We take the view that it should be the e-shops and not the platforms. But that can only be very clear if there are proper contractual obligations that need to be upfront stated. So practical point, if you're a platform operator, make sure your contract covers you. Still on imports, I mentioned that we have very little duties, but alcohol, vehicles, cars are super expensive in Singapore. And to buy a car, I need a certificate of entitlement, and that's not even my tax. And it's $152,000 as of this week. Yeah, I'm like, who's going to buy a car? But anyways, money laundering. Just coming back to some goods which are taxable. So alcohol, vehicles, and a couple of other products. That's it. Now, I mentioned this because sometimes you have parties importing products into Singapore and you think it's a food product. And Joshua's in the middle of a case at the moment where Singapore Customs suddenly decides that, no, the product is actually alcohol. And now we're trying to sort of find all kinds of interesting arguments, and I must give it to the team. They're doing a really great job to say that, no, it is not alcohol. It's for cooking purposes and da-di-da. And it happened post-event, which means that if we have to go backwards again, potential penalties and so on. So like Melissa and Na said, don't admit straight off. Still on imports, if you do not want to deliver goods to Papua New Guinea from Jakarta, maybe you can come through Singapore, because one of the key things that we have is a free port. And the free port means that you basically come through Singapore, but it doesn't enter, and it can then move on, and we'll gladly take it out to PNG for you. I'm not sure of all of the routes, but yeah. A couple of additional elements. We also have advanced rulings that you can potentially obtain. We don't necessarily call them advanced rulings. That operates both inwards and outwards, imports and exports. So you get a classification guidance as such, and whether or what are the specific permits that are required. The tricky part is for imports, it's not all just customs. Depending on the nature of the product, it can be different parties. One last element, which is not part really of this whole thing I want to mention, is as we import goods into the country, and all kinds of consumer goods, and they may have licensing permits and so on, product recall becomes a very real thing. So when you're importing, say, through e-commerce, sometimes to undertake a product recall is not going to be easy. When can product recalls come up? In relation to food items, it could be suddenly there's an ingredient that's prohibited. And you don't go and get an advance permit for that particular ingredient. It is just that you check, you comply, you think it's in compliance, you import. But then there's a subsequent recall. So there are practical difficulties there. I'm not going to go into specifics. It is something that we do often, and Lydia is in the middle of one at the moment as well, where we are recalling a very popular product in Singapore. I won't mention what it is. So in terms of imports, there's a whole bunch of different issues to be considered. I just wanted to go back to GST for a second, if I may, with Tracy's permission. I mentioned that when you're importing into Singapore, GST is payable. So if you're a freight forwarder or logistics service provider doing it, you probably will ensure this is being done for your clients. Or if you are the major importer, you will ensure you're doing this. But again, e-commerce, a lot of us may be importing food products. We had a client who, on a regular basis, they are from a particular country, they love the snacks of their particular country, and on a regular basis, they would buy the snacks from the particular country. And one day, customs stops it and says, you haven't paid GST on this. So it's not even about the food permit, but food import permit, but no GST paid. So, you don't think about these things, but it does surface and it does cause constraints. If I may just go back, to one other point I wanted to mention, because there might be freight forwarders and logistics service providers in the room. From an export perspective, we talked about export control permits and strategic goods permits, right? If you as a logistics service provider are the person who's going to put your name on the EOR, exporter on record, then you need to ensure that the permit is in your name. And if you're a business using a freight forwarder, do ensure, who is the exporter on record, you or your freight forwarder. And if it's you, make sure you have the permit. If it's your freight forwarder, make sure he has the permit. This is another area where we see things being missed all the time, because we're just looking at it efficiently. I just want to take care of my logistics, but you miss out on these nuances.
Thank you, Carla. So I'm just going to quickly wrap up for Malaysia on this point, right? The position in Malaysia in terms of the common pitfalls that we encounter really are pretty similar with what's been shared before. Maybe not as drastic as Indonesia. Malaysia is quite a bit smaller, but being patient is still a requirement in Malaysia, because things do kind of sit at ports for quite a while, and the port authorities do need to ramp up on their efficiencies. But one thing we do encounter a lot is really issues in relation to incorrect or incomplete documentation. That is always typically a huge factor in terms of causing things to be delayed or not cleared through, or cleared through and then after that being subsequently audited, and there you go, your certain statuses or efficiencies can then get into trouble, right, with the customs authorities. So do keep that in mind. The position in Malaysia is quite different from Singapore in that we have a lot of permits that you need. For every single general import or export, you have your baseline permit possibly, but then depending on the type of good, you have additional licenses required, additional permits required, and each of the permit issuing authorities or licensing authorities it varies greatly depending on what the item is. So really, in terms of, as an example, your cosmetics, you do need that general permits from the Ministry of Pharmacy, the Ministry of Health, the Pharmaceutical Board, or aspects in terms of vehicles, you do need your various import authorities for vehicles. So all these various aspects are very important. Another thing is valuation and tariff classification. Very similar to what has been mentioned before. Malaysia, we also do have a regime where you can apply to basically get a tariff identified for a particular good. And this is very important if you have a lot of questions about how exactly should that product be itemized, because customs authority would always try and whack it with the tariff code that has the highest duties, and obviously we would try to get it at 0 duties, right? So that's definitely something to keep in mind. Okay, moving on. Now that we're post-COVID-19, or in terms of recovering, how have trade regulations really changed in this landscape? You know, how can businesses ensure that they are complying with applicable trade regulations when engaging in various transactions? And what are the best practices towards navigating such regulatory landscapes? We touched on some of them earlier, but Carla, do you have anything more to add to this?
You're not talking free trade agreements, right? Just
No, generally, yeah. Okay.
I'm drawing a blank. I'm sorry.
No worries. So,
one thing I want to mention though. I'm so sorry. I want to mention sanctions. And the reason I want to mention sanctions is because sometimes we forget about this living in our part of the world as well. Sanctions is something that a country uses as a political tool. So the most, the country that uses this the most is the US, obviously. And it's like, oh, you're doing this wrong. I'm going to punish you. I'm not going to let you sell goods into my country. I'm going to punish anyone else who buys goods from you. I'm going to identify this whole range of individuals, and I'm going to prevent them from holding bank accounts and so on. I mean, really, that's simply what sanctions are. Are they justifiable? To a large extent, yes. And different countries have a whole range of different types of sanctions. For many of our countries, we generally just follow the UN sanctions list as a general rule. Because if the UN body sort of imposes various sanctions, we all say, okay, we follow. And the common ones are the ones against North Korea, Sudan, and a few other countries where it is really treating individuals badly and so on. And in relation to North Korea, the kind of sanctions Singapore has, it's not identical to UN, but we draw reference, right? And it's really about preventing luxury goods from being sold into North Korea. That's one of the key things. Okay? So against sanctions, you need to look at the specific list. I mentioned sanctions also because it is not just about the movement of goods or movement of people. It's the currency you use. So we might be in Thailand doing business with a country in Europe, doing business with China, with Japan, or within Southeast Asia, and the common currency we use tends to be US dollar. I mean, just now I was sending off a fee code, and it reminded me that, hey, we did US dollar before, so why are we doing Sing dollar? And it's a Sing work. So we said, okay, let's go put US dollar. And you don't even think twice about sanctions, right? Thankfully for Singapore. But the point is, when you use that US dollar currency, you need to look at both parties. So it's not just looking at me. Who's my counterparty? Is my counterparty from a country which is sanctioned? Is my counterparty itself sanctioned? And if it is, then I might never get paid. I might never get paid because the US dollar transaction, the rule is it will always touch US soil before it comes here. It's electronic, but the clearance happens through the US, as an example. So think twice about the currency you're going to use as well when you talk sanctions. As I mentioned, sanctions with permission again, where one critical difference was Ukraine-Russia war, where because Russia is part of the UN Security Council, so it's not going to agree to a sanction against itself. That was one instance where Singapore, I think amongst the 10 ASEAN countries, were the only ones who issued sanctions against Russia. But we didn't do a blanket sanction. We did sanctions to basically prevent dual-use goods, electronic dual-use goods from being exported out of Singapore, and a couple of other things. So it's a limited sanction. But it is important because what you might have been doing as business before suddenly needs to be readjusted. So there were a number of changes that needed to be undertaken there. Last point about sanctions, and I know I'm throwing these phrases, but if you're in a business that needs to be alert, be aware of blocking statutes as well. So blocking statutes are the reverse of sanctions. Using US just as an example, for instance, they impose sanctions everywhere. So the EC started out issuing blocking statutes, basically saying, US, you impose a sanction against Iran. I disagree. I have a blocking statute, which means that I will respect your sanction only in these limited instances, but not others. The UK did that too, and last year China did the same thing as well. But that puts you in a difficult position, because if you're using US dollar vis-a-vis a transaction in China on the prohibited or sanctioned goods, then, or companies rather, then do you comply with the US sanctions, or do you comply with the Chinese blocking statute? And there are a lot of litigation that goes on about this. Unfortunately, none in Singapore yet, so I haven't done a litigation, but I do advise on these things. So sanctions is another critical trade element that we do need to look at.
Thanks, Carla. So let me just quickly wrap up on this question as well. So, and we've spoken quite a bit in terms of ensuring compliance earlier, right? In terms of making sure your documentation is proper, don't be so quick to settle, and just being patient in terms of looking at these different aspects. But certain best practices also include, if let's say, for example, you're so good at getting your documents in order, and you're in a very, very heavy import-export trading type of industry, you can look at applying for certain statuses. In Malaysia, we have this authorized economic operator status, where AEO companies, where basically you get fast-track customs clearance, right? Because you have that track record of doing things well. And with all these type of benefits in place, then at least you can clear through customs very quickly. I believe this concept's pretty similar.
We have the same concept.
Yeah. So it's great to hear that, at least we have these aspects of moving things along very quickly.
Yes, I do.
Yeah. Okay, and next is really the next question I just want to quickly talk about is on free trade agreements. So we're all members of ASEAN, and therefore we have that very powerful free trade agreement that we have all currently operating under right now, which is the ASEAN Trade in Goods Agreement, right? Which allows us to basically trade within ASEAN countries practically tariff-free. But to what extent are you guys aware that we have the new Regional Comprehensive Economic Partnership Agreement, or the CPTPP, the Comprehensive Progressive Trans-Pacific Partnership Agreement? It's a mouthful. So, Nazli, you have quite a bit to share about this point. Maybe let's hear from you on this.
Okay, thank you, Tracy. Regional Comprehensive Economic Partnership sounds so fancy. It was actually born 2011 when there is a conference involving Asian countries in Bali. So our government is going to repeat this story. We are the initiator, okay? Whatever. The premise of this, what we call it, the world's largest free trade agreement, is that it's going to foster the welfare of its country members. ASEAN consists of 10 countries, and now we become 15 members, which means it's going to have a lot more foreign direct investment, a lot more movement of goods, a lot more elimination of tariff. However, Indonesia also faced so many opponents for this mega foreign trade agreement. In particular, because they believe or they fear that Indonesia will become the only supplier of primary goods. and Indonesia will become the recipient of so many goods from other members, such that the trade deficit is going to be higher, much higher. So many of Indonesians actually oppose this mega foreign trade agreement because of that. They are afraid that the small, medium enterprises will pay the price. They are afraid that the unemployment will take its toll. It is very early to see the impact because Indonesia effectively just rejoined 2nd of January this year. So we need to wait and see whether it will bring the real value that the survey, the research show. The research say that Indonesia trade is gonna be up by 7% by joining this, and by elimination of tariff, which is 1% of the total, will bring 2% of surplus. So let's see whether this research and study actually proven correct. It is still too early to determine whether it is going to be useful, but we are very optimistic. Our president, our government is very populist driven, which means they don't want to be hated by their own people. So what it means is that even if they're so brave in international forum campaigning this, in Indonesia itself, they're going to practice practitionism, which means they're going to protect the local product. So how are you going to jive between what we are actually initiating and how we protect the local product? This is something which is very interesting to see. Indonesia recently passed the law, the omnibus law, perhaps you heard, which is investor favored law. And so people keep demonstrating on the street against this law. And with this passing of this regional comprehensive economic partnership, hopefully is going to support the reform, which is the omnibus law is intended to be. So right now, let's just wait and see. Fasten your seatbelt. There's nothing dull in Indonesia. Welcome aboard.
That sounds great. And I'm just mindful of the time, so maybe we'll just wrap up the panel for today. Maybe just some final closing remarks, or in terms of maybe either any updates that within local laws that you want to highlight, or any common issues or key concerns that you think your local jurisdiction typically encounters that you want to just close off today's session with. Melissa.
I would like to make a practical comment on the use of free trade agreements in Thailand. I mean, we have some great preferential tariff rates that we can take advantage of under various bilateral or regional agreements. But in order to use it in Thailand, it has to be implemented into Thai law. So there needs to be a ministerial notification to actually implement it. But what we often find is the implementation is not perfect. There may be some cases where one word or one conjunction is out. So sometimes, particularly when you're in a multinational, your head office trade compliance people may tell you, why not import using this preferential tariff rate under this FTA? What you should do in Thailand is just double check the local implementation in the subordinate legislation. I mean, some years back we had one case between the Thailand and Korea FTA where there was just one word left out in the description of a good, and that created chaos because customs didn't agree that our imported product matched the description of the good as set out in the local law implementation. So that would be my very practical suggestion. Do not just rely upon the English language free trade agreement and its schedules, annexes. double check the local law implementing those provisions just to be on the safe side.
Thanks, Melissa. Carla?
So free trade agreements are very important for a country like Singapore, which is tiny, right? And our hinterland is really all of ASEAN. And so I think understanding ATIGA, which is the agreement, oh God, what does ATIGA stand for? Trade in Goods, ASEAN, thank you, ASEAN Trade in Goods Agreement. But there are also multiple ASEAN Korea, ASEAN China, as well as like Singapore Korea, Singapore China, Singapore EC, multiple trade agreements. And all of these are effectively replacing your World Trade Agreement for all intents and purposes. But to take advantage of these trade agreements, which can make the movement of your goods a lot easier, which can allow for the movement of people from country to country easier, if you have the free trade agreement. In one instance, it allows for a certain foreign country, individuals to buy property in Singapore without having to pay the 60% tax that foreigners have to pay, for example. When you buy a property in Singapore, 60% tax. This country doesn't need to, people from this country. So anyways, free trade agreements are fantastic. But recognize that free trade agreements means that you need to know whether the particular product is coming from your country. So if I want to take advantage of a Singapore free trade agreement with some other country, and so the good is moving out of Singapore, potentially I need to say that this is a Singapore origin product, which is not always easy, which is why I want the ASEAN free trade agreements. But anyways, for each of our different countries, note where your raw material is coming from. Note whether labor can be added to the value to change the origin. Note whether the final product is bananas or is it banana pudding, and are they different, and so on and so forth. Because if you get the origin of your product wrong, then potentially you think your goods going into another country free of duties, but actually you got it wrong. And you end up being smacked with duties going backwards, but you also end up with non-compliance, which then attracts penalties. And that's one of the areas that we do a lot of work in, and strangely, Tanya seems to pick up a lot of these pieces of work. And so we call them certificate of origin, rules of origin. Your certificate of origin is getting that certificate from the appointed regulator. And if you don't provide the information accurately, if your COO contains inaccurate information, that creates the problem as well. A lot more technicalities, but it is the end of the day. So if you're interested, very happy to share with you. But we do defense work in this area quite frequently with the regulators. Not just in Singapore, we've had cases with Korea, with China, with India at different points in time. Thanks, Tracy.
Thank you, Carla. So just final points for Malaysia to wrap this up. Malaysia also, we do want to really encourage a lot of clients, bear in mind rules of origin, not just only in relation towards ensuring that you don't get whacked with duties, but you can also keep in mind your multiple free trade agreements with their varying rules of origin, manipulate and pick the one that suits you best. And in order for that to work, you need to really be very familiar with the varying thresholds under each different agreement, or the different various rules of origin that we have there. Because in Malaysia, I mean, same with all of ASEAN countries, we have so many different free trade agreements we are a party to, we're a member state of. Know your counterparty that you're importing from or exporting to. Understand how to then identify the best rules of origin that suits your situation. And another thing is just going back on that export control aspect. Export control misclassification is something that some of our clients really encounter quite a bit, especially MNCs that have US headquarters. A lot of times the trade compliance manager sits out of the US. Then they'll think, globally we'll all apply our US export control classification regime. Doesn't work in our respective countries. Very, very different classifications. So please keep that in mind, because your trade compliance manager that sits out of the States may not necessarily know what's the local domestic classification requirements. So with that, anything else to add on? I'm looking at the lovely ladies across the panel. I'm mindful it's 4:53, it's an evening, and I don't want you guys to get caught in traffic. So we'll just end the panel here. If you guys have any other questions, feel free to approach us after. Thank you.